We start off, we got two cases, correct?
Correct, Your Honor. Both.
And you are Caleb Landry?
Sir.
In 23 CR 908, the earlier case, you were charged with the state jail felony of burglary of a habitation on or about February 14th, 2023.
Let's break this down. Burglary of a building might sound like a light offense, but in Texas, it's still a felony. That means real prison time, up to 2 years in state jail. This isn't a slap on the wrist. It's a criminal record that sticks.
And that carries with it no less than 180 days up to 2 years in the state jail. You'll understand if convicted.
I think you said burglary of a habitation.
I said burglary of a building, state jail, a burglary of a building,
Yeah.
not a habitation. A burglary of a building, which is lesser than a burglary of a habitation. It's no less than 180 days up to 2 years in the state jail. Burglary of a habitation is a second degree felony. Do you understand what you're charged with here in this?
Yes.
And in 24 CR 2225, filed on October 23rd of last year, this states that on September 17th, 2024, that you committed the state jail felony of burglary of a building. It's like the same building owner. The victim is the same as the previous case.
Probably discount tires. I don't know.
And it goes on to state that you have, in this indictment, you've been convicted in 2005, felony offense of illegal possession of marijuana, a state jail felony out of Harris County, Texas. And in 2015, you were finally convicted in the criminal district court here of delivery of marijuana. And that doesn't affect the punishment range on this, does it?
Yes,
It does, Judge. If he's
Two prior state jail felonies on separate.
it has to occur.
makes it a third
So,
degree.
well, your punishment range is in two things that are problematic. Your punishment range will be enhanced if this is proven true to what would be a third degree felony punishment. It's state jail felony, but it's punished as though it was a third degree felony under law. And you were looking therefore at no less than two, no more than.
More than now, here's where it gets serious. Because he's got prior felonies, the punishment just got upgraded. Instead of state jail time, he's now facing 2 to 10 years in real prison under third-degree felony rules. No probation, no breaks.
10 years confinement in prison and a fine up to $10,000 can be assessed. Plus, if this is true, you are not eligible for probation in either of these cases. Do you understand?
Sure.
Okay, that's should be a lot on your mind here. What are we going to do today?
Your Honor, the state has tendered an offer of 12 months or 1 year in the state jail facility. And
How much time does he have credit, if any? Please. Okay, go ahead.
Mr. Landry's advised that he's refusing that. Is that correct?
Okay,
You don't
That's what you wanna do?
The state's offer.
that's what you want to do?
Speak up.
It's a hard decisions, but it's your life. Right now, we're at a crossroads. It's either going to go that way or this.
This is that moment. A life-changing decision. Take the 12-month deal now or risk everything with a trial. What would you do? Roll the dice or take the deal? Let us know in the comments below.
Which one?
To be clear, one of the things that hasn't been stated, he is not eligible to receive probation from a jury.
I said that.
Should he do that, I will, if he continues down that path, I'll withdraw the state jail offer and give the enhancement notice on both cases so that they're both dealing with third degree. Sure.
Okay, it wasn't. Yeah,
It wasn't included in the
indicted.
first indictment for some reason. We must have recovered them by the time he alleged to have committed the second offense.
He has 17 days credit.
Okay, not a lot.
Not a lot.
Let me ask something here. What's his bond?
What are your bonds? 5 each.
$5,000.
Each. Be probably 5 each, Your Honor. That's what he seems to.
He's correct.
Okay. When was this bond posted? In 908. I'm looking at July 15th of 2024, correct? Is that right, everybody? That's what I'm seeing.
If that's right, then
It's $5,000
he's alleged to have committed the second offense while he was
in
on bond.
September. Yeah, we got a bond issue.
This is wild. He's accused of committing another burglary while already out on bond for the first one. That's like setting your own house on fire during a fire safety hearing. Judges don't just dislike that, they crack down on it.
You committed, according to the grand jury, and this second offense after you had been charged and in this earlier case, and you posted a bond of $5,000. Let's see, stand by. Looks like the amount of bond was fixed at $25,000 on July. I'm looking at another document that says July 20th.
He made the accusation that run the initial arraignment may have been 20. I'm
There's a 715 of $5,000 on 7 that he paid on 715. But then there's a warrant for an arrest at Capias, burglary of a building, filed on July 16th. Okay. And the bond was fixed. Who's selling these?
He probably got
Says the amount of bond fixed by the court in this case is $25,000 here.
That was probably the initial arraignment. He didn't post bond.
Yeah, it was an arraignment.
And he got out on accusation after that, and the warrant popped up sometime after he was released on accusation in the bond.
But it's showing
On the warrant
5,000.
was set at 5.
Is that right, Lacey? It's showing 5,000 on this. Okay.
When he was arrested on the
And all of this was done though before it is alleged that he commits this next crime, 24 CR 2225.
He may have been out on the accusation on the second offense.
The second offense is on or about September 17th of 2024. All of this is July and July.
Which the initial bond he made in 908 was made on 7/15 of 24,
Yes. Of
$5,000.
yes. Then what?
And then it looks like the bondsman surrendered that bond when he was rearrested, and he made another bond in this case on 2/10 of 25.
Of how much?
The initial bond was
No, I'm talking about the new bond.
Should have been 10 if there was an air for this.
it wasn't an AFR, so it was a surrender.
Oh, right.
Is it showing it's still 5,000? Yes.
Yes,
Okay.
still 5,000.
Okay. And then when did he post the bond in 24, 22, 25? The new thing.
10 of 25,
What was that bond?
5,000.
Yes. Well, on what day now?
2/10 of 25.
Okay.
That's after the.
Yeah. That indictment had already been
Right.
prepared and has those prior convictions, and then you have that.
Right.
It just slipped. It must have slipped by somebody. See, on this indictment, here's what's once again, I don't know how this is happening. On this indictment, on the face of the indictment, 7/20/23, that's me writing it. When I get the bond, I'm setting the bond at $25,000 plus a GPS device. Do you even have a GPS device? You don't even have that. I don't know what are my orders doing here that aren't being followed. I don't understand. But this was my orders on July 20th of 2023. Thereafter, those are changed.
Wait. The judge ordered a $25,000 bond and a GPS monitor, but somehow it got reduced to $5,000, and no, GPS something's off here. This isn't just about the defendant. The system itself is being questioned.
Or
That means the court. I didn't have anything to do with it.
you didn't. Yeah, you're You're always the first suspect, but you've been cleared in this
I would
one.
like to take credit.
Anyway,
I don't have any notes to explain, Judge.
those were being changed without, and this court had authority over this case, and somebody else was changing these.
It was post-indictment, yeah.
It was post indictment after I had signed these orders, which are equivalent to an order, which is inappropriate, but we'll figure it out. Anyway, this court doesn't find $5,000. I mean, I put $25,000 up here, but I did this before this indictment shows up.
Right.
And then this indictment shows up, another burglary of a building, which is alleged to have occurred on or about September 17th of 2024, after he was on bond here. Your bond's $100,000 in each case. Plus, you have to have a GPS device as a condition of bond. So this is irresponsible and of your part. Once you are charged with a crime and a bond is set, and you're presumed innocent unless found guilty. But these are probable cause decisions by the grand jury that you probably committed these crimes, which are what we base bonds on, as the probability a crime has been committed. And we use the circumstances of the case and the criminal history. Your first bond of $5,000 is the same type of offense that you post a bond. A few months later, you're committing another of the same offense, the same type of offense, as though.
And boom, the judge slams down a new order, $100,000 bond on each case, and a mandatory GPS. Why? Because this man allegedly kept committing the same crime while already facing charges. That's bold. And the courts had enough. None of
this mattered to you. You weren't taking it seriously. You are now. We're going to take it seriously. You can't just keep committing crimes and think that you can just pay a small bond and not that additional information and additional crime commission won't have a bearing on it. It does. So those are the orders. You must have a GPS device, and the bonds are amended to $100,000 each because of your criminal history and the fact that you're committing the same crime after you posted a bond in the first case of a similar matter. Just a few months after that, you're committing the same kind of crime, according to the grand jury. Anyway, that's the orders of the court. Next event, you set these for trial. It'll be set for trial. Thank you. That's what we'll do.
Okay.